Continues to be the closing arguments underway in this unprecedented, historic hush money trial involving the former president. I do want to put up this live picture right here on Live Now from Fox. Again, just inside of the courthouse, outside of the courtroom, potentially going to hear some remarks from the former president after closing arguments. We're going to bring into the conversation right now attorney, friend of the program, Jeremy Rosenthal, here on Live Now from Fox as well, talking about the latest in terms of what we know. And the prosecution said it could take 4 to 4.5 hours for their closing arguments. Is that too long? Because it feels like we're going late into the evenings right now.
That's a long time. It's not too long for you and me because we get to go and have dinner and, well, maybe they feed you there. I don't know. They should. But if you're stuck in the jury box, that's a long time. That's a long time to have to sit there and be a captive audience. They got a lot of details to go over. They've got a lot of documents. They've got a lot of phone records. They've got a lot of financial stuff. They've got a lot of witnesses to recap. So I do think that they've got a lot to recap here. So 4.5 hours is a long time, but you're summarizing 4-5 weeks worth of stuff. So I think we all get it.
Yeah, I think we all understand. And of course, you want to kind of put a bow on this trial as well. Of course, it's involving a former president. I do want to talk about a main point that happened today is the Trump defense attorney told the jury that they should think twice, quote, before sending a man to prison. And he was admonished for those comments by the judge, calling them outrageous. What do we make of those developments from inside the courtroom?
There are 4 permissible areas of jury argument. You are allowed to recount the evidence. You are allowed to make deductions from the evidence, why it says what you think it says. You're allowed to respond to opposing counsel and things that they say. And the prosecution is allowed to make a plea for law enforcement, and the defense is allowed to kind of make a general societal thing. You're not really allowed to talk about the direct result of the case. And not only that, because prison might not necessarily be a direct result of a conviction. So the argument was probably improper. Now, is it outrageous? I don't know about that. I think that closing arguments get really passionate. You're there trying to do your Matthew McConaughey, trying to get the jury to cry. You're getting worked up and it's emotional. So I don't know that it was outrageous. And then the judge did what was called a limiting instruction to the jury later on, which just kind of highlights it. And sometimes, and believe it or not, that you're kind of flirting with a reversal when when you're the judge and you start commenting on things like that. So I'm a little surprised the judge took it that far. But under the letter of the law, that argument was probably not proper.
And as a lawyer, is that an unwritten rule? Is that something that you're specifically not asked about? And could there be consequences for it?
There could be consequences. You could be held in contempt, but I don't think that would be appropriate in a case like this. I think that most judges know that in the heat of the moment that a lot of lawyers get really worked up, that it's about passion, and that you're trying to really argue your client's case. So most judges they might sustain an objection if that's an improper argument, and they might, grant a quick admonishment. Closing arguments get really passionate. I mean, these lawyers have been working a long time on this case. They believe, both of them, what they're trying to convey to the jury. So yes, you could probably get held in contempt in theory, but the question you have is, was what Mr. Blanche said mistrial bad? I don't think so, and I don't think it's particularly close either. But again, letter of the law, a little outside of bounds, but it's just one of those. It's like hitting the wide receiver 5 yards out of bounds, or maybe 2 yards out of bounds. Yeah. It happens, and you take your medicine, you go on. But I don't think it's any more severe than that. Maybe 10 or 20 yards out of bounds, yeah, then you got a problem. But
yeah, it's a big strike. It might not be the ultimate strike, though, in this case. And I do want to ask you, because you mentioned passion there during closing arguments as well. They want to see kind of your conviction in their argument to the jury. But he also potentially talked about the memorability factor. And Todd Blanche also called Michael Cohen the gloat, the greatest liar of all time. What do we make of that, and do you think he was trying to maybe stick that in the minds of the jury?
Maybe trying to plant a flag. That's what you do with the memorable tagline. There's certain words that you use over and over and over throughout the trial and hope that the jury picks up on it. Another thing that they did, I think probably very effectively from the defense's standpoint, is at the very opening statement, he says, we're going to call him President Trump throughout this trial. And so when they President Trump, when the jury's back there deliberating, if they pick up on it and they start calling him President Trump in the jury deliberations, that's where that type of a thing pays off. So if you're going to call Michael Cohen the gloat, I don't know that the jurors are necessarily going to take that one to heart. But it's catchy and maybe they pick up on it and maybe it sticks in the back of their brain. You've got 12 people back there and you are trying to get as many sticky messages as you can to them so they can go and utilize it while they're deliberating.
Yeah, very, very good point. It's going to be interesting, and you would love to be a fly on the wall inside of that jury room during deliberations. I do want to ask you, as we kind of go into the closing arguments, into the jury deliberations, and whether he's found guilty or not guilty, the fact that it has to be intent to have this wrongdoing, how difficult is that to prove in some of these cases?
Intent is a fundamental part of criminal law there, and I'll give everybody watching on LiveNOW Nation just a quick rundown. So there are two components to the vast majority of crimes, and this is Law School 101. One is called mens rea, that is Latin for guilty mind. The other is called actus reus, and that is Latin for guilty intent. When you converge the two, you get a crime. So intent is almost always an integral part of that. However, there are certain exceptions. Speeding does not require intent. DWI does not require intent. But intent can be a big deal because if it's an accident, then it can really excuse it. In this instance, Trump's real argument here is that Michael Cohen really concocted this all on his own. Now, maybe that was a scheme that Cohen had to get himself reimbursed for money that he was trying to steal from Trump. That was not an angle I think that we saw coming, but we saw developed really towards the very end of trial. And you've got to put, again, the entire challenge for the prosecution in this case is to put Donald Trump's thumbprints on the crime. They argued in closing argument, this is not a case about Michael Cohen. Of course, you and I, we talk about Michael Cohen a lot more in this case than we do about Trump. That's how trials sort of work. But the prosecutor tries to come back and refocus that lens. No, this case is about Donald Trump and his actions. That's their argument. And so that's kind of some of the things that they're trying to get their sticky points across to.
Very, very interesting. All right, as we get closer and closer, closing arguments still underway. I do have to ask you, as we kind of wrap this up, I know it's been more than a month time since we had opening statements as well, and you kind of read some research that people make up their mind during the opening statements. In your mind, maybe how important are closing arguments? Can they seal it? Is this different than other maybe trials that people have researched in the past, or are the jury's minds made up already potentially?
They're made up, but they may not all be made up in the same direction. You've got 12 of them back there. What you're trying to do in your closing argument is you are trying to argue to your base. You are trying to fortify and motivate the people who are for you. Because when you have 12 people, let's just say for argument's sake, you got 4 not guilty, 4 guilty, and 4 that are undecided. You want your true believers to be the true believers, and you want them to be able to work on the other people in the room to flip them. So what you're trying to do is a little different than it is an opening statement. But I mean, I don't think that the lawyers are doing anything better today. So in closing argument, I don't know. Maybe we tried to persuade people. Maybe, I don't know.
Hey, maybe you could convince people one way or the other, as they need all 12 to kind of be unanimous there for a conviction. All right, Jeremy, we know we've been talking to you almost daily since the trial began, and of course, it might be over soon. The jury will soon have it in their hands after the instructions tomorrow morning, and then we'll see deliberations. Thanks again for your time.
Hey, thanks, Andy. Bye-bye.
All right, take care.